We've been reviewing the book from Paul Hajek from Clutton Cox. Don't even think about buying or selling your home until you've read this book. It's a 5-star rated Amazon book, and we've been going through the chapters, just really explaining some more information about these chapters. Taking a look at conveyancing contracts. Now, how standard is the standard contract for sale? Now, some conveyancing solicitors have a lot more experience than others, particularly people like Paul Hajek at Clutton Cox. And many have also relied on a standard contract of sale to make life for sellers and buyers as easy and as fair as possible. And over time, a fair bit of tweaking to what are now called the standard conditions of sale has taken place. Until 2003, there were 2 conditions of sale, a national and a standard utilised by conveyancers. The former had reached its 24th edition and the latter had reached its 5th edition in April 2011. So common are these standard conditions that most solicitors, when issuing a draft contract for sale to a prospective buyer solicitors, only refer to them by name and do not produce the conditions in full. The new standard conditions of sale, 5th edition, draw together best practice and designed to be used as part of a new protocol in conjunction with the Law Society Quality Conveyancing Scheme. Now remember, the need for a written contract of sale signed by all parties to the transaction is laid down in statute. There's no such thing as a verbal contract for sale of land. You may have heard the phrase, a verbal contract is not worth the paper it's written on, used in this context. Now what's different with this new statute? Now, the rather antiquarian chattels and chattels price have been replaced by the more modern sounding contents and contents price. The seller has no obligation after exchange of contracts to insure the property except where the property or any part of it is let on terms that require the seller to insure it, i.e. a leasehold property. Risk now passes to the buyer on exchange, so the buyer must insure the property from exchange of contracts and not completion of the contract. Very, very important. Make sure you get insurance on exchange of the contract of the property you have bought. Now, neither seller nor the buyer party can rely on representations made by the other unless these have been made in writing by them or their conveyancing solicitors, but it does not exclude liability for fraud or recklessness. The above examples are just a few of the changes made in the new 5th edition. If you want to get more information, please check with your conveyancing solicitor or get in touch with cluttoncox.co.uk about conveyancing contracts.